Welcome to the Roundup, True Crime with Mike. Today I'm taking the time to talk to Brett from the Prosecutors. We're talking about trials openings and trial strategy. If I talked in a monotone voice and didn't explain why we were here and that I just wanted to say you would hear from a list of people and not tell you why, you might zone me out. And let's take the opposite approach, which was we're here because my client was framed. It was a much more emphatic approach, and I'm here with Brett, and I wanted to talk to you about several things about how to run a trial. First, let's start with trial openings. I'm curious, Brett, if there is a formula that prosecutors kind of use when they do their openings.
I think formula is probably a strong word, but I think that the best lawyers, the best defense attorneys, the best prosecutors, they understand that it's the opening that's the most important part of the trial. I think a lot of people, and maybe even a lot of lawyers who are just out of law school or haven't had a lot of experience, think the closing is the most important because that's in the movies where they tie it all together and they give this big impassioned speech that leads to the conviction of the guilty or the acquittal of the accused or whatever. But in reality, you have these jurors who are coming in and they're not like us. They're not following the case beforehand, hopefully. And they don't know everything. In fact, they're not really supposed to know anything. In most cases, they don't know anything. Famous cases might be a little bit of an exception, but nevertheless, they're coming in and this is your first opportunity to explain to them what the case is about and what you're going to be trying to prove. You're talking about a formula that if there is a formula, it's that. You have to build a foundation, build some sort of framework that you're going to hang the evidence on as you go. Because in a trial, the way the evidence comes in is through witnesses. And you really want the jury to have enough of an understanding of where the case is going from the opening that when they hear, they already have an idea, there's a framework, there's a roadmap. And when they hear the witnesses, it's fleshing out things they expected to see. And so that's really, when you talk about a formula, the formula that you want. And you're right. You know, look, not all lawyers, not all trial lawyers are great public speakers. You know, if you've watched enough court TV, you've seen a lot of really boring lawyers who
Yeah.
end up winning a lot of cases because that's honestly, a lot of times trials can be pretty boring. And when you're a juror, and I've never been a juror, I wish I could be a juror, but when you talk to jurors, one thing they'll tell you is it's a very different experience watching a trial from the jury box as opposed to watching it from television. So there are times where we find it boring and not engaging, where since they're so in it, maybe it's a little bit better. But it's hard to sugarcoat that if you have two lawyers get up an opening and one of them is confusing and maybe doesn't really explain things very well, doesn't lay out a very good roadmap, doesn't have a focus, isn't clear in their presentation, and then the next lawyer gets up and has a very simple, straightforward, this is what we're going to show. Yeah, that is a huge advantage for that second lawyer.
Okay. Well, I guess if you haven't guessed, the case that I've been following now is the Karen Reed case, and to me, that kind of is the problem. It's now been 3 weeks, so it's hard to. We finally caught up to kind of talk about this. But when I had watched the opening of that trial, I had saw that Lally, who is the DA in this case, really was slow opening his case, and I lost him early on, even though I kind of knew what the case was going forward, because he was like, "I'm going to talk about this uh, in order of time, and then you're going to meet Fred, George, Wilma, and Barney, and like you didn't know who these people really are." And then he talked about some things, and finally, I think a little bit at the end of the 45 minutes, he was like, "Well, here are the kind of forensic evidence that we're going to talk about." And then I'm trying to remember Unetti. I think Unetti and Jackson are the two defense lawyers. Come on, and they open pretty emphatically with my client has been framed, and they go in this spiel of how they've been framed and what they're going to try and prove over that case. So to me, um, sorry, to me that Lally is very like monotone, where Unetti and Jackson are a lot more emphatic in their presentation. So I don't know how that's going to affect it overall long term in that case. I mean, the other thing that's kind of affecting the case is that it's a 6 week, 2 month trial. So I mean, it's hard to remember back to the opening when you're three. I mean, we're 3 weeks in, and we haven't even gotten to any of the forensic evidence. So I don't know. I was just wondering your opinion on, especially these long trials.
Well, and I think that goes back to, so there's a few things that you've touched on there. And I think when you're an attorney, when you're a prosecutor or a defense attorney, it really doesn't matter. I mean, you both have an objective you're trying to accomplish, and it's going to be different depending on the kind of case you have. And it's going to be different depending on the kind of trial you have. If you have a trial that's going to last months and months, weeks and weeks, then really what you should shoot for in your opening is something short, something straightforward, and something memorable. Because, like you said, the jury's not going to remember many of the fine points and details 3 weeks into a 10-week trial, 8 weeks into a 10-week trial. They're going to have forgotten most of what you said in opening. And hopefully by the time you're 8 weeks into it or whatever, it doesn't really matter whether they remember the fine points of your opening because you've already started to convince them with the actual evidence. So in a case like that, timeline presentation is fine. That is one very popular way of organizing an opening, and it works in a lot of cases. But you need to keep it short and you need to keep it punchy. Now, this is an advantage that the defense has. Remember, they don't have to build a case. They don't have to prove elements. They don't have to go first. All they have to do is put some doubt in the jury's mind. And there's a lot of different ways you can do that. So they have a little bit of an advantage there. But when you're the prosecutor in a case like that, you really have to keep in mind what kind of case you're going to have. And you see sometimes you'll see prosecutors who will do these long, complicated, confusing openings. And you just wonder, like, why did you decide to do that? You don't have to prove your case in the opening. In fact, you can't. We call it an opening statement, not an opening argument, for a reason. You're really just supposed to lay out, what's this case about? What are we going to show? What's some of the evidence you're going to hear? What's some of the forensics you're going to see? And I think brevity is the soul of wit, and it's also the soul of convincing oratory, as I wax poetic here. And the shorter you keep it, I think the more convincing it can be. So, and particularly if you're not the most fiery speaker, you have to make up for your deficits sometimes. And if you are a fiery speaker, you want to be fiery. If you're somebody who's really good at organizing, you want to keep it short, organized, and tight.
Okay, I guess that kind of brings up another question about that, because in this case, it's only one DA. I think there's probably two at the table. I can't remember counting them. That only one's been really doing all of the work, while the defense is tag teamed it. They've had the two guys that are both fiery, and then they've also had the lady that was, I think she's a lot more inexperienced, but she only did one cross of one woman. But I don't know why he hasn't had anybody else speak, but it just seems like he's, I don't know. I mean, I guess you kind of have to know that office to know how good their prosecutor is in that office to know if they could have had somebody else cut him in and out.
And honestly, part of that may be what he prefers and what his team prefers, because there's a couple different ways you could do it. Think back to the Murdaugh trial. So you had 3 or 4 prosecutors, maybe even 5, who took at least one witness, who presented at least one witness. And a lot of times what you see is back and forth. So you'll have one attorney who's going to do witness 1, and then when witness 2 comes up, you want to have a different attorney for lots of different reasons, because they're fresher, they can really focus on that other witness. You don't get tired as quickly. The jury doesn't get tired of you as quickly. So that's one way to do it. In the Murdaugh trial, I feel like they did that. I mean, obviously, Creighton Waters was the main prosecutor, but you saw several different people take important witnesses. Another way to do it sometimes is you do have one voice. You have one voice for the team, and then the other attorneys are really supposed to be focused on what's coming in, how it's supporting the case, where the weaknesses still are, what you're not getting that you should be getting, really paying attention on cross-examination, just trying to be a second brain almost for whoever the voice is for the team. Because when you're up there and you're asking questions, it's hard to catch things. And one of the things that's really difficult, and a lot of people have difficult with is you have an outline of what you want to hear. Maybe it's super detailed. Maybe you have every single question you're going to ask and every single answer you expect. Maybe it's topic based. I want to hit this topic and this topic and this topic, and these are the points I want to make. But a lot of times when you're asking the question, the most difficult thing is listening to what the witness says and reacting to what the witness says, not what the next question is on your outline. And sometimes it's very helpful to have somebody else who they're not getting ready for the next witness who's coming up, focused on sort of their job. They're focused on the testimony that's coming in, so that while you're up there asking the questions and maybe you miss something important, they catch it and they can let you know, like, hey, you need to follow up on this. And when you ask that question, he said this thing, it's really important. You didn't follow up on it. So there's different ways of doing it. And it seems like that's their approach is like I said, the almost second brain approach.
Okay, thank you for that explanation. The other question I kind of when I had, and since I'm not a lawyer and I don't have to, or I'm not a trial lawyer or a lawyer, and I don't have to come up with it, is that what we don't understand is that there are certain ways you can ask questions during a trial. I think everybody's kind of heard it when you hear it on Law and Order, like you can't ask a leading question, or right, you can't ask a hypothetical question, for example. So I think how do you prepare as you go into the trial to get your mind in that mindset that for when you're doing your direct, and I know people are the direct is when it's your witness coming up, you have to ask, you got to start with like foundation questions, then you got to ask them the questions about that after they've made that answer. You can't just ask, did you watch a movie at 2 p.m. at the theater on that day? I mean, you have to say, well, tell me about what happened that day. Did you go anywhere specific? Did you go anywhere? Those are the questions, and I think it's really hard for us people that don't have to do the trial, how we get into that mood. Is that something you just get into a mindset when you're going into trial, or is that just second nature for someone that's in this position?
You really have to think about it. And each witness you have to think about, and you have to think about your defense attorney, because what sort of posture are you in with your defense counsel? And I think this is one thing people really don't understand. And frankly, I don't even understand it fully, even having been a lawyer for a long time, because you would think prosecutors and defense attorneys are just absolutely, they hate each other. They're antagonistic. They're going to object to everything. I've had cases where, we did one trial that lasted a month, and there might have been 5 objections total in the entire trial. Just nobody objected to anything. And everybody kind of we knew it was going to be long, and everybody wanted to move it along. And everybody felt like it was in each other's best interest for this not to last forever. And so maybe you didn't have to lay as much foundation as you would otherwise. Maybe you could just kind of get right into what the meat of it. And maybe every now and then you could lead. But yeah, putting that aside, not leading is really hard. It's much harder than people think it is. There will be times where you'll be trying to figure out, how can I ask this question without leading someone? And leading, the most obvious example would be if I said something like, and then you went to the bar. Yes, that's leading, right? Like I have stated the substance of the answer in my question. So the objection would be leading, and I would have to rephrase it. And I would have to say something along the lines of what you were saying. So what did you do then? Then I went to the bar. And so you have to decide, where are you going to start? Because, we don't want to start. So when were you born? Well, tell us about your childhood. Number one, it's not relevant. Number two, it's going to bore the jury to death. So you have to get to the place that matters. You have to get enough foundation about them, who they are, why they're important, why they would know anything about this case. So just imagine you have somebody, you put somebody on the stand. What's your name? Where do you live? How long you been there? Do you know the defendant? Yes. How do you know the defendant? Well, I've known her since grade school. So you are pretty good friends. We are. And so notice there, like, how did you know each other? Well, I've known each other from grade school. So then I asked a question which would be leading ordinarily, and probably was even leading there. But because we've sort of established that they're really good friends, I can kind of recapsulate it in the way that I want it to be and ask it. And a lot of times a defense attorney would not object to that. So anyway, so you keep going. Did you know we're on this date of significance? Do you remember that day? Yes. Let me take you to the evening. what had you been doing up to that point? Well, I cut the grass. I got some groceries. I mean, I guess you would be cutting the grass because it was snowing, but whatever. I got some groceries, and then I was supposed to meet some friends at a bar at such and such. Did you meet them? Yes. What bar was it? This bar. Anyways, and so
Yeah.
you just sort of you're walking through step by step till you get to those points that are really important. And it can be frustrating because I remember one time, and you've talked to all these people beforehand. This is not a mystery. Like, you've sat down with them, you've told them exactly what you're going to ask them. A lot of times you've asked them the questions. And there was one case I had where we had a witness who, when we were doing the prep, told us something that was really good for us and we didn't know before, about a conversation he had had with the defendant and some admissions the defendant had made. And we were really excited about it. Get him up on the stand. We ask him, everything's going exactly the way we expected. Then we get to this point where before he had told us about this phone call he had with the defendant. And I said, "Do you ever speak on the phone with the defendant?" "Yes, I did." "When was that?" Blah, blah, blah. "Do you remember what was said?" Not really." It's like, wait a second. A week ago when
Oh,
we met, you were telling me all this other stuff. So then you're like trying to get out of them without leading, right? Because if you start to lead, the defense is going to object. And you
yeah.
can lead a little bit when you're trying to remind somebody of something. So it's like, so during that conversation, did you discuss this? I really don't remember. I tried every way other than saying, didn't the defendant tell you this, to get him to say it? And he never would. And that can be one of those difficulties. And it also can be another reason that second attorney can be helpful, because maybe if you're struggling with a way to get it out of them, that person, you take a moment, speak to that person, they say, "Hey, why don't you try asking them this way?" And then that can be a much better way to do it. The other thing that happens, and the other problem with being the prosecution is, as you said, you have to lay the foundation. So you're putting on a lot of witnesses, particularly in the beginning, who may not seem that important, who may not seem like they have that much relevant information. And you, particularly if you're a watcher at home and you know all the facts, you're like, man, why don't they just get to the point? We just need to get to the thing that really matters. But in the prosecution's mind, it's as if they are starting with people who have no idea what's going on, and they can't just tell them. They have to do it this way. This is the way our system works. So a lot of times in a lot of trials, it's hard to have those really big blockbuster moments early on. You really have to build the foundation so everybody knows exactly what we're talking about, exactly what the situation was, and then later on you can start adding in the really damning bits, for instance, if you're the prosecution. And obviously the advantage of doing it later on, particularly in a long trial, is the last things you say are probably going to be the things the jury remembers most, not necessarily those first few witnesses or even your opening statement.
Okay, yeah, I would. That's kind of one of the hardest things is trying to make sure you. I mean, I wanted to kind of talk about that too. Is trying to get the last thing said is something the most important, because it would be really hard if the most important thing you said was in the first 10 minutes of the first person, and then you go 6 weeks, and then 6 weeks, and then it's hard. But let's talk about the strategy in this kind in the Karen Reed case, because I don't know how much you've been paying attention. It's been all chronological. I mean, all the events happen somewhere between, like, I mean, they started like at 10 or 11 when they got to the bar, and it went to like 7 or 8 in the morning. I guess, I mean, some during the day, but it was a lot. There's a lot of people involved. A lot of people were at the bar, and then a lot of people went to the house, and then so you're going through each of these people and trying and going through their timeline. And I think it's one of the things I think Lally is doing is he's being very defensive. I mean, I think for the first 3 weeks he's been very defensive for the most part, because the defense has come up with the strategy that we're being framed, that my client was framed. So to me, it sounds like Lally is trying to fight off the framing part by putting all the. I mean, I think maybe there's another question about that too. Is putting all these 10 people that were at the bar in the house, saying eventually we'll be saying how. I mean, if you believe there's a conspiracy or a framing, all 10 of these people who you've seen testify before us have to be in on it. And can you see these 10 people working together to hide a murder in the house? So I think people are really think it's really slow, because that's his strategy right now, is to get all these people out of the way before he does any forensics.
No, and I think that's right. And I think, look, There are many different ways you could do this. Ordinarily, I think if you're the prosecution, if you fall into trying to rebut the defense as you go along, in some ways you've fallen into their trap. You're now fighting on their territory. Like they've got you arguing what they want you to argue about. And even by doing that, it lends it a little bit of credibility because it signals to the jury there's an alternative theory. It's serious enough that I am taking it seriously and I'm trying to oppose it. And you're going to have to decide which one is best. In this case, I think what the prosecution is doing is exactly what you said. Yeah, this is boring. And yeah, it's repetitive. And yeah, it seems like a lot of these people, maybe we could just have not put them on at all. But when it comes to the end, now, the defense has really, they've gone all in on their theory. The defense doesn't have to offer a theory. We talk about this all the time. They can just poke holes. They can just go for reasonable doubt. They don't have to try and give you an alternative. And the danger of giving an alternative, if you're the defense, is because you kind of almost lose that advantage. When you offer the alternative theory, even if it's not reality, even if the jury is not really supposed to be weighing the two theories against each other, that's exactly what they're going to end up doing. It's human nature. So now they've gone all in on that. And he's going to be able to say exactly what you just said. He's going to be able to say, you heard from all these people. And I bet you were bored out of your mind listening to those people. And you were thinking, I wish the prosecution would quit putting all these people who just say the same thing. Well, here's the thing about those people. Every single one of those people that you heard, the boring ones, the ones who seemed irrelevant, every single one of those people would have to be involved in this conspiracy for the defense's theory to be true. Every single person you heard would have to be lying. And that's pretty powerful, right? I mean, it's one thing if you're saying the only witness they got is a convicted drug dealer who did this as part of a deal so he can get out of prison. That's a pretty powerful argument if you're the defense. But when the prosecution has person after person after person, ordinary person, and they all have to be lying, they all either have to be lying, so drunk they don't remember, mistaken, in some sort of conspiracy, conspiring with each other and conspiring with police and conspiring with everybody in the world, that becomes a little less believable. And when you as the defense have set that up as the alternative, for a lot of jurors, if your alternative falls apart, that is powerful evidence in of itself for them that you're guilty.
Yeah, and I think the other thing that he's doing by bringing all these witnesses too is that he's trying to not give them the argument or the theatrics of saying, "Oh, that the third guy at the house you didn't bring into the situation. Maybe he knows the truth." So they're bringing every single person that went to the house that night to say, "Well, what was the story?" And they're all giving the same story. John never showed up at the house. We were wondering why, if he was going to come in. Why did he go? We all kind of left. We never saw we never saw the body at 2 a.m. when it was dark and snowy. We just went right by it and wish we had seen him. And so but I mean, because there's been so much publicity in this case, they're trying to hide to say, "Oh, well, if the guy that was supposed to be there first isn't testifying, then he's the one who knows all the secrets." And so I think that's why another reason that we are getting it is so competitive.
And that's
not competitive, but repetitive.
And that's a good point. And I think you understand, you get defense attorneys pretty clear because defense attorneys, much like prosecutors, there are certain playbooks you can always turn to. There's the witnesses are all coached playbook. So there's, really focus on just how much the prosecution prepped a witness to try and say later on. They were all coached. They were all saying exactly what they were told to say. There's the why didn't you hear from that guy approach, which you were saying, the missing guy. So, there were all these people who were there, and yet the prosecution didn't call that person. And you see that a lot in cases where there are co-conspirators, and there are multiple co-conspirators. A lot of times, for whatever reason, you can't call everybody who's involved. It could be any number of reasons. Maybe that other person is still contesting and they're hostile to you because you hadn't gotten to that trial. And you might have a defense attorney in an underlings. You've heard so much about the guy who supposedly was ahead of this. You've heard all about him, but he never testified, did he? They didn't call him. Like, so that is a strategy that you often see from the defense is everyone you didn't call. There are two police officers in the car, and you only call the one police officer because the other one would just be saying the same thing. There were two officers in that car. Why didn't we hear from the other guy? What does he know that the prosecution doesn't want you to know? So yeah, I mean, and I think you've sort of hit the nail on the head in the last question that the prosecution has chosen to approach this from the try and rebut the defense's position before the defense can even make it. So calling all the witnesses does that. Knowing they're going to claim a conspiracy, putting everybody on the stand does that. And I think that's what you're seeing from this prosecution team, and probably what you'll continue to see as they go.
Okay, I guess I mean, and also not how you since it's a lot of the in the middle of it. I also wanted to ask you the defenses of one of their strategy. I guess is always they seem to be hammering points to me that are like they should just do it once and then just like leave it as let them infer it instead of keep pounding and pounding it. Because one of the big things they've been trying to get is you guys are like for like the let's take the paramedic for example. When she was in there, she said, "Well, he did." I mean, she when she talked to Karen in the morning, and she told me, "I hit him, I hit him, I hit him." Right, right. So, but then what they're trying to do with her is say that you're really good friends with the person, one of the people in the house, and you guys were on track teams together back in high school. Like you guys went to vacations together, you went baby shower together. But I mean, they're like these baby showers and these track teams were 10 years ago. But the defense team keeps hammering, "Did you know him? Did you know him? Are you covering for him? Are you covering for him?" Where I think it would have been I mean, to me, I don't think a paramedic is going to cover for somebody in the house. Their better approach would have been, "Are you covering for your department?" Or, I mean, do you want? I mean, I think it would have been better for them to say, "Hey, do you want to be a paramedic for life? Do you want to be in the Canton Fire Department? Do you want to be somewhere in law enforcement?" Like, would your? I mean, do you think you might lie? I mean, do you think you might have heard something based on your career path? I think that was a better strategy for them because as I was a juror, if I see them just hammering these stupid things home, I'm going like it's going to throw me off. And I was curious your opinion too, if I am wrong.
No, you're not wrong. I just think these are sort of tactical decisions, strategic decisions that every defense attorney and every prosecutor has to make going into a trial, and they're hard, and they're where the rubber really meets the road, right? It's like the eternal question about whether or not you put your client on the stand. And if you put them on the stand, you're going to second guess that forever. If you don't put them on the stand, you're going to second guess that forever. So they've decided that this is the way they're going to go. They're not going to be subtle about it. They're going to be overt. They're going to hammer it. They're going to try and make this case. And I think part of it might be, maybe they think the jury is inclined to believe conspiracy theories. There's a lot of people who are. Maybe they think the local people who would be on the jury are already skeptical of the fire department and the police department. Maybe they think that their best hope is that somebody on the jury actually knows more about this case than they let on during jury questioning, and actually maybe is already inclined to believe these kind of conspiracy theories. And so you want to build it from there. And I don't know what's better. And it's always until, if at the end of the day she's acquitted, we'll be saying, wow, that was brilliant. What brilliant strategy by the defense. Whereas if she's convicted, obviously we'll say, man, they should have done something different. But I think outside of her claiming this was some sort of tragic accident, which is one way to do it, it's sort of the Casey Anthony approach. This was a tragic accident. It wasn't a murder. Had no intent to do this. This case is overcharged. You could have done it that way. That could have been the choice you made. They didn't make that choice. What they decided to go with is that this is this pretty large conspiracy that involves a lot of different people, both present there and in different capacities, firefighters, police officers, whatever. And once you do that, you got to sell it, right? So, yeah, I mean, I can think of lots of people that I was friends with in high school and for years and years after high school that now I barely even talk to. I might call them a friend, even though I hadn't seen them in 15 years. Maybe I'd call them a friend, or maybe I'd say it's somebody I went to high school with. Somebody wouldn't lie to cover up a murder for them. But maybe somebody on that jury is going to think, she was so close to that person. I just don't think we can trust her because her testimony is so damning, right? I mean, you got to undermine that somehow. So I don't know. It's a tough question about what the best approach is, and I think the defense has made their decision about how they're approaching this case, and they're going all in on it.
Okay, I guess my other question doing that, is it too late if they wanted to shift to the intention argument? Have they gone so far in? Because to me, I think what's going to get Karen convicted of second degree murder is going to be her lawyer's strategy. Like, if she had just at the front said, well, it was an accident. I didn't mean to hit him. I didn't know I did. They could have got it off. But now that they're trying to blame everybody, including the dog in the kitchen sink, as being responsible for the murder, that like the jury, in my mind as a juror, would be like, why are they doing this? And not like, it makes you look worse if you do believe that they did it, compared to like, well, even if she could get on the stand and even lie and say, well, I just totally I was so drunk, I blacked out, I didn't realize I hit him until 5 a.m, and then when I went back I was like, oh my god, what did I do?
Is it too late? Probably. I mean, I don't know. I mean, I guess you could evaluate how it went at the end of the prosecution's case, and then put her on the stand, and she could completely come clean and do that. And I guess you could do that. The problem is, once you've attacked all these people the way you have, and with the vitriol, I mean, the defense is made a conscious decision about how they are doing this too. They're not being respectful and with these people. Like, I feel like if you were going to do that at the end, you would be nice to these people. You wouldn't, you'd barely have any questioning at all. You'd let them lay out their story, and then you put her on the stand and say everything they said was true. They're all good, honorable people. But the one thing they didn't know is that this was a terrible accident. I'm the only person who knows that. Here's exactly how it happened. I didn't realize I'd done it until the next day. I freaked out. I realized that there's no way he was still alive based on how long he'd been there. I even Googled it to see, and there was nothing that could be done. And I made a terrible mistake. I should have told the truth in the very beginning, but I didn't. Right? But I think once you've gone all in on these people, everyone who's testified is evil and they're liars and all this other stuff, how do you then turn around and say, well, okay, never mind, they were all telling the truth, but it was me all along? I feel like the credibility problem then would be so huge.
Okay, I don't know if I'm breaking up, you're breaking up a little bit, so kind of hard. But yeah, I don't think she can. I think it's too late to take that approach, even though I think maybe he talked about it in the opening as like a, well, maybe if you don't believe it's conspiracy, you could still think it wasn't intentional. I mean, and one of the reasons why this trial is lasting is 2 months is because it's second degree murder. I think if it had just been the vehicular manslaughter, it would have probably been less than a month, and then maybe even 2 weeks. I mean, some of these, I guess I'm not normal to it, but I would think some of these middle of the class drunk driving, hit and run, or whatever, have to go through our system pretty quickly normally, and they don't normally. It's not normally a 2-month trial.
Yeah, and I don't know what all will happen behind the scenes. I mean, I know there was initially it was going to be brought as a lesser charge, and the grand jury upped the charge. I don't know how many discussions there were about possibly pleading, if any happened at all. I'm not an expert on the law up there, so I don't know how lesser included offenses come in. Because I'll just say this: if you're in some jurisdictions you don't really have lesser included offenses. You have what you charge, and that's it. And the jury can either find you guilty on that or not. If that were the case, then they should have gone all in on it was an accident. But it seems like they're going for all or nothing. They're either going to get her acquitted, or she's going to get hit for second degree murder. And maybe it was second degree murder. I mean, to me, and I haven't followed it as closely as you have, but just seeing what's coming out, the whole, I don't know, he got attacked by the dog, and it's like a Naked Gun movie or something. Like all the stuff that had to happen, and all the all the bad things that had to happen to him that night for this to happen and not to be her. Not to mention like all the conspiracies and everybody who has to be in on all this other stuff. To me, it just feels like, sure, she hit him, but what's her culpability for doing that is the real question in the case. And if I were the defense, that's what I would be hammering on. I'd be trying to keep this woman from being convicted of second-degree murder, which is a much more serious offense than some of the
Mhm.
lesser included that she could be charged with or she could be convicted of. And I think it'd be pretty easy if you took it head on to create some doubt there. I think if they had gone head on against this charge, acknowledged the accident happened, but that it was just that, an accident, and that maybe alcohol was involved, so she's got some culpability beyond just a simple accident. If they had done that, I don't think she would have been convicted of second-degree murder. Maybe she won't be anyway, but I don't think she would be I don't think there's any way she would be. I think there would have been jurors on there who would have said, how can we know for sure this wasn't just an accident? Maybe she was mad at him. Maybe she, sent him some mean text or left him mean voicemails. That doesn't mean she meant to do this. But I feel like they've given that away. They don't have that option now.
Yeah, and talking to my defense attorney friend, that's a little bit different. She said they should hammer home that he died of hypothermia, not died from the car crash. Because if you were trying to kill somebody, you wouldn't just leave them out on the snow, because they could wake up at any minute, dial 911, and then all of a sudden you're in trouble. So I mean, if you were, as I said, if you're trying to kill them, hypothermia is not the good way, that is not the way to go, unless you put them in a cave in the Colorado mountains or something.
No, I think that's right, and that's actually a pretty good argument that it goes against the intent of the thing. Even if leaving him out there was a really bad thing, the the higher up you go in the murder scale, the more intentional it has to be. Or at least severely reckless. It has to be for you to be convicted. And if you can take away that intent, then you're taking away that higher level of culpability. It's like, the Rust case with Alec Baldwin. Nobody thinks, he intentionally shot that lady. Nobody's arguing that. That's not what people are arguing
Yeah.
about. They're arguing about a much lower level of responsibility, which can still get you convicted of a crime, but not put in prison for a very long time.
Yeah, I think for Massachusetts, second degree is life. So I mean, I guess it's always funny what life really means. I think life usually means 25 years, but it's definitely. I looked it up. I think vehicular manslaughter was like 5. So I mean, you could do 5 and then parole at 2.5 or 2. So if you get just the vehicular or manslaughter, it's so much less than that potential life sentence. And if it gets stacked too, I mean, she could. I mean, theoretically, she could also just be convicted for the Robert Kennedy crime too, which was just leaving the scene of the accident. So we'll have to see what happens. I mean, it'll be interesting. I guess 2 more months. I guess they actually they stopped for CrimeCon, so they're not doing it during CrimeCon. So
How nice of them. And look, I think one question,
I
which maybe you can tackle on a future episode, is what the effect of the media was on this case. We all know about some of the absurd things that's happened in this case, but I mean specifically on Karen Reed and her defense. If this were a case that no one had ever heard of, it weren't famous, there was no media coverage, it was just the exact crime in a little courthouse in Massachusetts, and there were 3 people there every day to watch trial, would her approach have been the same? Would the defense have been the same? Or would this have been a much more ordinary, typical, no conspiracy case that ended up in some sort of, you know, like you said, vehicular homicide deal, and nobody ever heard of her? She spent a little while in prison, and then she was out and she went on with her life.
yeah, I don't. I mean, that's a good question. So I don't know what kind of that answer to that one, but I think, I mean, it definitely and I don't remember, and maybe the people that did watch it or pay attention earlier, there was two grand juries that were brought for her charges, and then the second grand jury was the one that upped it to second degree. So I don't know if it was the her starting to blame the dog in the kitchen sink for what happened that bumped it up to second. Did they find the text messages that she left after the accident, or did or something or did they finally get the car telemetry data? I think that showed her like backing up at 25 miles an hour. Is that what finally came in and said, "Oh, this is second degree"? I mean, if she's going 25 miles an hour, there's that seems like an overkill. So I don't know what came in to uh to bump it up. So if anybody knows it, they could put it in the comments when this is put out on the YouTubes. So
Yeah, and we may
okay,
never
I
know,
think
but I
that's
think you're
probably
going to see
it
that
for
later on.
today. Yeah, I mean, he hasn't. I mean, we're gonna get into the forensics probably starting. I'm thinking the middle of next week to the end of next week, or maybe the following week when we're gonna start getting into those. I think the big things are the car telemetry. We're gonna find out how much, and maybe it will bore us to death. How much information comes from a Lexus, like a 22 Lexus. Like, does it have GPS? Does it have at 12, 24, and 31 seconds that like so that's what we're going to find out, and we're also going to hear a lot about his ways and his phone and how accurate GPS. I mean, is GPS accurate to 15 feet? Is it 5 feet? Could he have been in the house with it at this GPS location, or how accurate it was? And then the last one will be is that what crazy is his Apple Watch, as it's rumored that his watch stopped doing monitoring at 12:31. So that was 12 minutes, like, sorry, 7 minutes after he got there, his Apple Watch stopped tracking any movements. So, I mean, so now do we know when time? I guess it's not time of death since he was still alive, but it shows you when he was hit if his watch stopped it. So, I think those are all kind of the forensics that we're going to hear in the next couple of weeks.
And those could be really powerful. I mean, I'm pretty sure a 2022 Lexus will brew a cup of cappuccino for you. So I think we're going to learn a lot in the next couple of weeks.
Okay. Okay. Well, I just wanted to thank you for taking the time to talk to me this afternoon or this evening. And I guess I will see you in a couple of weeks at Crime On. I'll bring the book to get it signed.
Always a pleasure, Mike. Always love being on with you.